Now, Mr. Campbell, you are now recognized for 5 minutes for your oral remarks.
Well, Chair Wagner and Ranking Member Sherman and the rest of the committee, I want to thank you for the opportunity to testify today. And I want to start out by stressing that the views I'm expressing here are my own. I'm not representing a client. I'm not representing my firm. I'm not representing the views of my colleagues. What I am representing are my personal views based on my experience as a practicing ERISA attorney who routinely advises clients on matters of fiduciary obligation, on the prohibited transaction rules, and also because from 2006 to 2009, I was the Assistant Secretary of Labor for Employee Benefits, head of the Employee Benefits Security Administration, the agency at DOL that is now proposing these rules. And based on that experience, I'd like to share some observations with this committee about the proposals. Ordinarily, I don't think the Financial Services Committee would pay much attention to what the Labor Department was doing in a regulation because you wouldn't have a reason to ask the question of what are the impacts on the capital markets and on the financial services provided to individual retail investors and retirement savers. But this isn't an ordinary rule. I want to commend you for taking the unusual step of reviewing a Labor Department rule in this committee because the Labor Department has taken the unusual step of attempting to insert itself into the retail marketplace for financial services to individual retirement folks, disrupting insurance, securities, and banking financial markets that this committee oversees. Individual retirement accounts and individual retirement annuities collectively hold more than $13 trillion, with a T, trillion dollars in assets. And under current law, Congress established that there is no separate standard of care, there is no separate remedy for services provided to those IRA owners. Instead, Congress inserted the regulation of advice to IRA owners into the existing financial services system. The IRA owner chooses who they go to seek financial services from, and that's regulated by the state insurance commissioner or by the SEC or by the other appropriate entity. Congress did the opposite of this with employer-provided retirement plans under ERISA, because those are not individual retail products, those are institutional trusts. In which someone else is making decisions for workers. So in that case, Congress said, yes, we are creating a special fiduciary standard for these institutional organizations where workers don't make their own decisions. And yes, we're putting the Labor Department in charge of that. That is not what they did with IRAs. But that is what the department's proposal is seeking to do. It is seeking to export the rules that were designed for this special employer-provided situation into the $13 trillion retail marketplace for individual retirement savers that Congress never intended to have apply in that space. And they do this through, I'm just going to call it a clever trick that I like to call the DOL two-step. And the first step of that is they dramatically expand the definition of what is considered fiduciary advice for purposes of the prohibited transaction rules in the tax code. Through a quirk of the law, DOL regulates those prohibited transaction rules both for ERISA plans and for tax purposes. The effect of that is that ordinary, perfectly legal and appropriate transactions in which, for example, there is a commission paid to an insurance producer or a broker-dealer now become illegal, prohibited compensation by virtue of calling that a fiduciary relationship. That brings up step two of the two-step. In step two, the department says, all right, well, we will create an exemption that allows you to still be able to get paid for providing that advice, but only if you comply with an extensive series of new conditions, one of which is the imposition of a standard of care that is almost identical to the fiduciary standard of care applicable to employer-provided benefit plans. In other words, DOL through the back door tries to impose a standard on IRAs Congress denied them the ability to impose through the front door. Now, all of the conclusory statements I just made about congressional intent and what DOL has the authority to do and what it doesn't are not my own opinion. This is what the Fifth Circuit Court of Appeals said when it overturned and, vacated the 2016 rule the department used, which had a very similar two-step built into it. And the effect of all this will be for the Labor Department, if these proposals were to be enacted, the Labor Department would have an entirely new federal regime that of regulations with significant details of reporting, disclosure, et cetera, a whole new extensive regime that would apply at the same time as state insurance law, at the same time as regulation best interest, or the regulation of RIAs as fiduciaries. So you would have competing regulatory systems simultaneously applicable to the same advice to the same people in an IRA. And that is clearly not going to result in lower costs. That is clearly not going to result in greater access. I know I'm over, and I'll just close with one last thought, which is I've heard a number of people say, well, it'll be different this time. The Labor Department has changed this proposal compared to 2016. People aren't going to lose access to advice. I did myself lose access to advice.
Gentleman's time's expired.
In 2016. And if it can happen to me, it can happen to anyone else.
Thank you, Mr. Campbell.
And Mr. Campbell, you lost your advice, and you were about to tell us a really good story, but your time ran out. You did work for the government for a little bit, and so I give you a minute to explain what happened.
Well, yes, indeed. So I have, amongst my retirement savings, fortunately it was not my only retirement vehicle, but I had a relatively small balance IRA. I still do have this IRA. And I had placed it with a broker-dealer on a transactional commission basis on purpose because it's a long-term savings vehicle. I don't trade frequently, and paying an annual fee would be an inefficient way, an inexpensive way to get those services. Because the account balance was too small, right after the 2016 rule went into effect, and it was in effect for about a year and a half before the Fifth Circuit vacated the rule, my broker-dealer called me and said, look, I'm sorry, my firm is no longer going to allow me to make recommendations to you in this account. You're below the size that we're going to be able to do that for. And as a result, we'll take your orders, but we can't help you with recommendations.
Okay, and clearly that's what I know the number of you believe. So I appreciate that, okay. But I do want to ask you this, or for anybody, I mean, when the issue of best interest went up, the question Mr. Sherman asked everyone except for you, Ms. Neely, said yes, and I think you did it mistakenly because of the double negative nature of the question. But I do think that you all believe that there should be a best interest of the client, of the investor. Is that not the case?
Absolutely.
And I think,
Absolutely.
I don't want to put words in your mouth, but I think that you said that these other states that have not yet taken up that standard should, and that they probably will.
Gentleman yields back. The chair now recognizes the gentleman from Michigan, Mr. Huizinga, who is also the chair of the Subcommittee on Oversight and Investigation, for 5 minutes.
Thank you, Madam Chair. I'm going to start with Mr. Campbell here. You had worked at the Department of Labor, 06 till when?
I was at the department from 01 to 09, but I was the assistant secretary from 06 to
6 to, okay, got it, okay. Where are the lawyers? Where the hell are the lawyers giving the DOL, much less the SEC, advice that they're coming back at an issue that the courts in the Fifth Circuit have already ruled on? I mean, they tried this in 2015. I happened to be chair in 2017 of this subcommittee and ranking member in 2019, where we had hearings on these. And I went back over and looked at my comments back then. And it's like Groundhog Day. Here we are again. And I'm curious how this is working internally, real quickly. I mean, it's a little rhetorical, but I do not understand how they can look at what has come out of the courts and take another run at this.
I would agree with you. I think the Fifth Circuit decision was clear, unambiguous, and not particularly vague as to you don't have the authority, Department of Labor.
Maybe those lawyers are off trying to track down hackers to their X accounts and all the other stuff, but they certainly don't seem like they're giving very good advice.
The chair now recognizes the gentleman from Wisconsin, Mr. Steil, for 5 minutes.
Thank you, Chair Wagner. The Fiduciary Rule would restrict Americans' access to quality retirement advice at a time of high prices and volatility. It would harm retirement savings, and the risk here isn't just theoretical. In response to the 2016 rule, companies began to take the very steps we're warned about today, raising minimum account sizes, reducing face-to-face support, and cutting offerings. And making matters worse, the Biden administration is committed to fast-tracking this rule, ignoring public input, and likely, in my opinion, violating the law in the process. Under the Administrative Procedures Act, agencies are required to make decisions based on the comments received and are not permitted to prejudge the results of the comment period. This is exactly what seems to be occurring. President Biden openly endorsed the fiduciary proposal exactly as proposed on the day it was proposed. He's effectively prejudged the outcome of the process. Showing further disregard for stakeholder input, DOL refused to extend the comment period beyond a mere 60 days. The Department of Labor has said that they've heard the industry's arguments before and really don't need to hear more. And to make matters worse, the comment period was carefully placed during the height of the holiday season, and the hearing was held before comments were finished. Again, this is an agency action to achieve a predetermined outcome that treats the core requirements of the APA as formalities. This should not be partisan. 8 Democratic senators made the same arguments in a letter just last month, arguing that the flawed process is inviting legal challenges. If I can start with you, Mr. Campbell, and I'll come to you, Mr. Berkowitz. Do you share my concerns about the process in which DOL has pushed this rule forward? And is the rulemaking process differed from more normal rulemakings in the past? Start with you, Mr. Campbell.
Yes, sir, it does absolutely differ. And I do think the process is not compliant with the Administrative Procedure Act. In particular, holding the administrative hearing in the middle of the comment period denied a meaningful opportunity to comment on the rule.
Have you seen that before, where they've held that in the middle of a comment period, or did that seem rushed to you?
I have never seen that before by any agency, much less the department.
What would be the purpose of that?
Presumably to rush the process by not waiting until after the 60 days expire to then have 2 days of hearing.
So an attempt to drive a predetermined result.
That's the only rationale I can conceive of for why they would do it that way.
Did it make it
Otherwise
more difficult for these comments to come to fruition, to be able to get thoughtful input due to the timeline, not just the mere 60 days, but also putting that during the holiday season and then jamming in the hearing during that process?
I think all of those are irregular. Not all of them are necessarily violations of the APA, but I do think the hearing in the middle of the comment period, I think that is a violation. I think it's inconsistent with DOL's own rules, its own procedures for promulgating exemptions.
Gentleman yields back. The chair now recognizes the gentleman from Pennsylvania, Mr. Muser, for 5 minutes.
So, Mr. Campbell, you've mentioned a few views here in line with the problems that will come from this rule. So if you have 67% of financial professionals anticipate that they will have to stop or reduce sales of certain products, could you offer a couple of specific examples as to what might not be offered to those in that lower asset class?
Well, I think very clearly one of the issues, as they identified, is that if you don't have enough money that we can profitably offset the expenses of serving you, we're going to have to require you to have more money or we can't serve you. That's just, as you say, that's supply and demand. It's a logical reaction. If I have to spend more, if it costs me more to provide advice to you because of the compliance burden, and I think it's worth addressing a misperception. This is not a gap filler rule that just fills up where best interest isn't in place. DOL is putting out a rule that actively replaces Reg BI with respect to these folks, actively replaces the state rules. Both apply at the same time. So that advisor is going to have to comply with Reg BI in all of its detail and the DOL rule in all of its detail, even those are already a best interest standard in place. So that is extremely expensive, and that will cause those minimums to rise and reduce access.
Gentleman yields back. The chair now recognizes the gentleman from New York, Mr. Lawler, for 5 minutes.
The proposal we are discussing today is strikingly similar to the failed 2015 DOL Fiduciary proposal. But there are some key differences between 2015 and today. Most notably, the SEC finalized regulation best interest, which requires broker-dealers to only recommend financial products to their customers that are in their customers' best interest. Furthermore, 43 state insurance divisions have adopted a similar best interest standard established by the NAIC. And lastly, we have a Fifth Circuit ruling that states the DOL overstepped its statutory authority when it proposed the 2015 rule. Mr. Campbell, given these factors, do you think that the recent DOL proposal is necessary?
I would argue it's absolutely unnecessary. I would also argue that it is not consistent with the Fifth Circuit and needs to be withdrawn.
Considering the Fifth Circuit ruled the 2015 proposal was outside the statutory authority of the DOL, do you believe the recent DOL proposal is outside the statutory authority of the DOL?
I do, because it attempts to apply a fiduciary standard to individual retirement accounts under Title II of ERISA, which Congress never established a specific standard of care for. They were to fit into the existing financial regulatory system, where in my IRA, when I go to an insurance producer to buy an annuity, when I go to a broker-dealer to get securities assistance, when I go to a registered investment advisor to get fiduciary advice, those are all choices I have, and the standard applicable to that professional applies. DOL is trying to change that without congressional authority to do so, so that the ERISA standard from employee benefit plans would be essentially the governing principle, and they don't have the authority to do that.
Mr. Campbell, since the Fifth Circuit's decision was issued, the Supreme Court has also issued its West Virginia versus EPA decision, which confirms and clarifies the major questions doctrine. Isn't the new proposal ripe for being overturned given its similarity to the 2016 proposal and the newfound interest in the major questions doctrine since the Fifth Circuit decision?
I think that's an excellent point. When this was litigated in 2018 in the Fifth Circuit, the major questions doctrine had not been determined by the Supreme Court. And essentially, this is a very appealing case for that issue, because for 40 years, the Labor Department's own regulations and guidance embraced the same view of fiduciary. They only changed it and only discovered a whole new power to regulate an additional $13 trillion in IRAs in 2015. So that is an example of the statute has remained the same, yet suddenly a newfound power emerges. That is the essence of the major questions doctrine. So I think that will be an issue should we get to litigation, which again, I would echo the calls of the others here for Congress to not let it get that far. But if we get to litigation, I think that will be one of the issues that arises this time that did not last time.
I'd like to take this time to thank our witnesses for their testimony here today. Without objection, all members will have 5 legislative days within which to submit additional written questions for the witnesses to the chair, which will be forwarded to the witnesses for their response. I ask our witnesses to please respond as promptly as you are able. This hearing is now adjourned.